Very warm good evening to all. Today we will be discussing a very important topic which affects our daily life, and that is the law of nomination. Now we all know that nominee is something which we find in bank records. We also find in government securities, Provident Fund, or also in the property matters in the society. If we are staying in a metropolitan city where the society you are residing in cooperative housing, so there also you have to appoint a nominee for the property which will be inherited by your legal heirs later on. But the meaning of nominee is mostly misunderstood, and courts from the Supreme Court to all the high courts and all the civil courts have from time to time have said the meaning of nominee is just an agent. He is just in a fiduciary capacity who is holding your property, your assets, your bank records, and also the insurance policies. Let's take a simple example to understand the LIC policies. When we speak about LIC policies, normally we have a nominee therein. But is the nominee is the only person who is going to inherit the amount or the compensation the LIC is going to give you? No, it's not true. LIC is giving the money of the insured person to the person who is actually nominated as a nominee only in a fiduciary capacity to hold the money, and all the legal heirs who will be there, they will be entitled to that in their equal share or whatever the way they can be class 1, class 2 as per the Hindu Succession Act if they are Hindu, or any other personal laws if they are Christian or Muslims, the way they are guided by their personal laws. Now, when we speak about nominee, always remember that nominee is an agent. Always try to tell your client that nominee is an agent. Nominee is not something who is going to take the complete property in his or her name. Now, why the lawmakers or law framers have come out with this concept of nominee? See, insurance companies or banks or the government departments, if let's take a Provident Fund department or any other government department, they are holding your money only in a fiduciary capacity. And once they give it to the agent, that is your nominee, he is again in a fiduciary capacity. Now, this property will be shared equally by all the legal heirs. And because the legal heirs, if they fight for their shares, they should not embroil that company or a government department or the cooperative housing society. If it is in a flat in a cooperative housing society, the cooperative housing society is the I would say chairman, secretary, or the management committee. They should not be embroiled in legal litigation which is going to be between the legal heirs for their share. They may be fighting or they may be quarreling, they may be litigating before the court. So the law protects that in a fiduciary capacity they are giving to the agent, and that is the nominee, and thereafter the nominee is the person who is responsible for the perfect, or the I would say the legal and the valid sharing of that property, that assets. So nominee is not something who is going to inherit the complete property. He is the only standing as in a fiduciary capacity. So always remember, nominee is just an agent who is going to receive the nomination in his name of the complete property. The flat, if it is a flat, it will be transferred in his name. If it is a government, say Provident Fund, also if there is a nominee and one or two members of the family are not nominated, then also they have a legal right to take their share. Even for insurance, if one son is nominated as a nominee, another son or another children are not nominated, or wife is not nominated, they will always have a claim with the person who has taken the money in a fiduciary capacity from the insurance. So this applies to Provident Fund, bank securities, government bonds, or stock holding. I would say share certificates or shares or debentures also. It may be a fixed deposit. It may be any Kisan Vikas Patra or any other investment wherein there will be a legal share as a by way of, I would say, as a legal heir. If you are Hindu, by way of Hindu Succession Act. If you are Christian, or Muslim or Parsi, by your personal laws, you will be guided here. So always remember, nominee is just an agent, and nominee is not something, someone who will inherit the complete property if he is nominated, even if it is an insurance policy or a flat which is worth 50 lakhs or which is worth 10 crores. So if this is the smallest, I would say, smallest information, if you can pass on to your clients, you will be having a lot of litigation which will not be coming to the court. See, in our country, the litigation, pending litigation is too much. For the 1 million uh, population, we have only 20 judges. The ratio is very less. So in this case, if we know the proper law and we can guide the our clients, it will be actually very easy. That sometime, because as a lawyer, we should know that nominee is just an agent. He has to equally, or whatever way the personal law guides, he or she has to share the property between the legal heirs of the respective families. So now next we go to the reading. I'll share the reading judgment. Just a minute. This is a Bombay High Court judgment, recent judgment in fact, of 2019 Justice Supreme. Sewakram Perumal Motwani was State of Maharashtra. One of the interesting judgment I've read in recently. Sakshi, you can unmute yourself.
Hello, ma'am. So am I audible?
Yes, you're audible. Start reading from here.
Yeah. So issue involved in this petition is whether continuing prosecution of the applicant for the offense punishable under section 306, read with section 34 of the Indian Penal Code, amounts to abuse of process of law, whether ends of justice requires quashment of the prosecution. All these applicants were named in the FIR number 610/2018, registered at Irvi Police Station, District Wada, as accused persons. Vishal Kailash Motwani committed suicide by hanging during the period 11/7/2018 till 12/7/2018. It was in their go down. Before suicide, he wrote a note blaming all these applicants for his suicide. His father, Kailash Pratapchan Motwani, filed complaint on 16/7/2018, and accordingly police registered an offence punishable under section 306, read with section 34 of IPC. The suicidal incident is having background of family dispute on account of property. Sewakram applicant number 1 and Manoharlal applicant number 2 are the real brothers. Satish applicant number 3 and Girdar applicant number 4 are the sons of applicant number 1 Sewakram. Whereas Pawan Kumar applicant number 5 is the son of applicant number 2 Manoharlal. On the other hand, deceased Vishal is the son of first informant Kailash, and Kailash's father is one Pratap. Sewakram applicant number 1, Manoharlal applicant number 2 and Pratap are real brothers. Deceased Vishal is graduate from Engineering College, Pune. He was desirous of starting furniture manufacturing unit. Applicant Sewakram and applicant Manoharlal were doing separate business. So to first informant Kailash, father of deceased was conscious of his rights and he started demanding partition of property. Cousin grandfather Sewakram and Manoharlal promised to give share in the property. Applicants also harassed the deceased on flimsy grounds, just keeping of articles, taunting the deceased frequently. Lastly, assurance to give share in the property was given. After the marriage on 23rd June 2018 in the family of Manoharlal, applicant number 2, applicants assured to give share in the property. However, applicants changed their words and blatantly refused to give share. It affected mental equilibrium of deceased, and he puts an end to his life between 11/7/2018 to 12/7/2018. Applicants claim that lodging of FIR is abuse of process of court. Sri Devani learned counsel for the applicants argued vehemently in support of quashing of FIR. He also relied upon various judgments. Shri Saoji learned counsel for non-applicant number 2. First informant submitted that this is not a fit case for exercise of inherent powers. He also relied upon various judgments. Shri Khan learned APP for non-applicant number 1, also submitted for facing the trial by the applicant before the trial court. There are two issues involved before us. First, whether this is a fit case for exercising inherent powers and whether facts and circumstances prima facie disclosed commission of offense under section 306 read with section 34 of the Indian Penal Code by the applicants. Law on the point of quashing. Law on this topic is well settled. It is no more res integra. There are curtain of judgments when inherent power is to be used and when it is not should be used, when it should not be used. The first informant or non-applicant number 2 relied upon the following judgments. Mrs. Rupan Diol Bajaj and another versus Kanwar Paul Singh Gill and another reported in 1996 RLW section Supreme Court 133B, Mahesh Chaudhary versus State of Rajasthan reported in 2009. S. Khushbu versus Kanyamal and another reported in 2010. Didijan Bhikshapati and another versus State of AP reported in 2008. Dhyanesh Anandro Gabane versus State of Maharashtra reported in 2007. And Chakradhar, son of Gopinath Jadhav and others versus the State of Maharashtra through police station and another reported in 2009. Supreme Court of Maharashtra 1434. On reading them, still we find that the ratio laid down in the case of State of Haryana versus Bhajandal reported in 1992 still holds good. Honorable Supreme Court has laid down certain contingencies under which exercise of inherent power is well justified. There is a rider for exercise of such inherent power. It should not be used generally, but it should be used sparingly. Furthermore, while undergoing the exercise, the court has to take prima facie view without going into controversial facts. Exercise of inherent powers is justified only in 3 contingencies. 1, to give effect to an order under this code. 2, to prevent abuse of process of the court. And 3, to secure ends of justice. It is difficult to lay down all possibilities wherein court is justified in exercising the power. That is why inherent power is recognized. Honorable Supreme Court has cautioned that while exercising such powers, court is not sitting as a court of appeal or revision. So the difference between discharge and quashing. Now, the question arises, is there difference in between power to discharge prior to framing of charge as contemplated in the section 228 of the Code of Criminal Procedure in session trial offense and power to quash the proceeding? If there is no sufficient material to frame charge, sessions court is justified in discharging the accused. The standard of inquiry expected at the stage of framing of charge is limited. There also court has to take prima facie view whether one material corroborates when another material is an issue german at that stage. But power to quash the proceedings are much wider. The ultimate test is whether continuance of proceeding will amount to misuse of process of the court and to the benefit of one and to the detriment of another. In a given case, there may be sufficient material to frame charge, but at the same time, it may be a fit case for exercising inherent powers. While doing the exercise, whether to use inherent powers or not, court may visualize stage post framing of charge. Court may visualize the consequences if evidence is adduced as it is on the basis of materials collected during investigation. If court finds that even after recording of evidence, no purpose will be served, court is justified in exercising inherent powers. Ingredients of section 306 of IPC, vice versa facts of the case. There are few judgments relied upon the applicant.
You start from it.
Okay. So on reading these judgments, certain principles emerge. When a person commits suicide, either he is responsible for that incident or someone else is responsible. This someone else will be legally liable if his act falls within the definition of abatement. Abatement is defined under section 107 of the Indian Penal Code. There are three modes of abatement. First is instigation, second is entering into conspiracy, and third is intentionally aiding. So it is only when deceased put an end to his life due to acts attributable to the accused, then only accused can be prosecuted. That is why Honorable Supreme Court has explained causal connection between the acts and the outcome should be established. So the court needs to see under what circumstances suicide is committed. Court had to see which are the objectionable acts attributed to the accused which persuaded the deceased to commit suicide. It is not sufficient. Court need to ascertain whether these objectionable acts fall within the definition of abatement. If it does not, then accused will not be responsible even though there is unnatural death of accused. We have not reproduced facts of either of the cases. Ultimately, the conclusion is based on facts. On this background, the allegation in FIR and suicidal note needs to be considered. In nutshell, the allegations are as follows. Applicant Sewakram Satish and Girdhar started quarreling with first informant due to progress in the business. Applicant Manohar, his son Pawan are opposing every fact of first informant. Applicant used to sit outside the shop and used to taunt the first informant. This has adversely affected deceased Vishal. Deceased got annoyed due to act of throwing away furniture. Sofa set kept outside shop of first informant by applicant Pawan taken place 2 months back. First informant somehow convinced the deceased. The deceased got frightened due to threat given 2 months back by applicant Satish to commit suicide and deceased went into depression. Change of stand after the marriage by applicant Manohar in denying to give any share in the property. Applicant Sewakram and his son Satish denied to give 1 paisa if deceased will start furnishing if the deceased will start furniture business. They instigated applicant Pawan Kumar and he abused first informant and threatened to keep articles at some other place and teach them a lesson with the help of PA to the chief minister. So the conclusion, admittedly, there is a background of family dispute on account of property. On one hand, the deceased and his family members were demanding share in the property, whereas on the other hand, the applicants under various pretexts avoiding and refusing to give share in the property. As per prosecution story, this episode is going on since last 2 years. Apart from the deceased, there are other family members, including the first informant. First informant can also claim right in the property, just like that of the deceased. Just like the deceased, the first informant is also said to be aggrieved due to alleged hostile approach of the applicant. So the issue is, first informant has not taken the extreme step of putting an end to his life. Furthermore, when deceased claimed that he is aggrieved and victim whether putting an end to his life was the only remedy available to him, answer will be certainly no. Legal remedies of approaching civil court was very much available to him. Instead of resorting to that remedy, the deceased took extreme step and put an end to his life. If we consider the period of alleged hostile approach, it was for 2 long years. It is difficult to believe that this hostile approach of the applicants was powerful enough to capture the mind of the deceased and due to which deceased lost his mental equilibrium. There has to be direct connection between acts of the applicants and suicidal act of the accused. The deceased must have been aggrieved due to denial of share by the applicants. But issue is whether suicidal act can be connected to the hostile approach. We know there are thousands of civil disputes where there is a hostile approach by one party or the wrongdoer. But does it mean that due to that, the victim is instigated to put an end to his life? We find that an element of abatement by way of instigation is missing in the present case. It can only be a civil dispute. The first informant had given a color of criminal prosecution unnecessarily. One can understand the psychology of the deceased in putting a blame on the applicants while writing a suicidal note. But the allegations in the suicidal note are not sufficient to fall under the definition of abatement. So link is not established. We do not find it convenient just to drag the case to conclusion of trial as contended by learned APP. Even if evidence will be adducted, it is not going to fulfill the test of abatement. So allowing prosecution to continue on such insufficient material will amount to abuse of process of the court. That is how this court has to intervene and use its inherent powers. So we feel that the case of quashing is made out. Hence, we allow the petition. We hereby quash FIR bearing number 610-2018 registered under section 306 read with section 34 of the Indian Penal Code at police station Avi district Wardha and consequential investigation against all applicants. We direct concerned court seized of the matter to pass consequential orders.
Thank you. Thank you, Sakshi.
Thank you, ma'am.
Sakshi, you can unmute yourself. We saw a very interesting judgment of 482 CRPC, under which the High Court of any state has got inherent power to quash any criminal prosecution launched against your client. Now, if you have read the judgment properly, you have followed the Sakshi, what you saw that this there was a prosecution between the family members and one of the person has committed suicide, and there were accused who were the relatives. Now, this was a totally civil dispute, and this man, because of some instigation or whatever it is, but a court has made out he committed suicide, but court has made out a case that it was a totally civil dispute nature. His mental equilibrium may be a different level. Somebody may be a very sensitive person, but in this case, the court said that there is no instigation and there is no criminal element made out of the section 306 of Indian Penal Code, where he was instigated for suicide. So the prosecution launch against, that the criminal case launch against the accused was quashed and they were acquitted of the charges. So this is one very important judgment by the Justice Supreme, and do read it. There is also one more thing I would like to point out. There is a Bhajanlal case mentioned here. I'll again share the judgment with you. If you go in the beginning of the case, just a minute. State of Haryana versus Bhajanlal. This is a landmark case which still holds good. It still holds good. There are some guidelines laid down by the Supreme Court in this matter. When these section 482 CRPC will come into play, and when the High Court will hear your case and will quash the cases. So if there is a misuse of the process of the law, this is the case which you have to refer. So any 482 CRPC application you make for quashing of charge sheet or the FIR before the Honorable High Court of any state, it is incomplete without mentioning Bhajanlal case. What are the guidelines, what are the contingencies, what are the conditions under which case can be actually quashed. So do read this judgment. It is one of the good judgment of recent time, and also the Bhajanlal case. If you have to any time go and file the petition for quashing before the Honorable High Court for quashing. Now today we go to another interesting topic, that is, do the Muslim women have a right to go to court and ask for divorce? Yes, the answer is yes. Under the Dissolution of Muslim Marriage Act, just write down this act, Dissolution of Muslim Marriage Act, under section 2, she has got the all the equal ground with the Hindu lady, Hindu woman for divorce. She has got under section 13 or under Hindu marriage, whatever the divorce grounds are given, almost all the grounds are same. And any lady, Muslim lady who comes to you and she says, I want to go to court and file a case of dissolution of my marriage for divorce, she can go and file. That is section 2. I'll point out this section also to you. See, this is section 2. Section 2 in the Dissolution of Muslim Marriage Act 1939, grounds for decree for dissolution of marriage. So the Muslim lady has got equal right as given in the Hindu Marriage Act for her right of divorce. There is also one more thing, that is divorce by mutual consent. If she wants divorce by mutual consent, she can go for khula, which is before the Qazi, the religious priest. But if the husband do not agree for khula, and there is no talaq between the parties by consent, that is by khula, Khula is one something where they go by consent, and in khula there is peculiar condition also attached to it, that she will be given the giving the consideration to the husband from her property or from her dower, whatever it is, whatever the conditions they agree for by mutually. So khula is mutually, but if he does not, the husband do not agree for mutual divorce, that is by khula before the Qazi, that is their religious this, she can always go approach the family court like any other woman in our country and ask for divorce, and she can file a divorce petition. And if you can make out a ground for plurality or whatever grounds are given in section 2 of Dissolution of Muslim Marriage Act, she will be entitled for decree of divorce like any other ladies of our country. So this is one more important section which you should be aware if you are practicing the matrimonial laws. And nowadays matrimonial disputes and property disputes are increasing. So succession laws and the matrimonial disputes, this is something which you should be having on your tips of fingers.